go ahead and get started. I'm going to turn it over to Chris Loebsack. He's he's the managing principal of our firm, one of the two who started the firm, and he's going to be talking to us today about fair housing.
Thank you, Michael. Well, for starters, everybody, happy Earth Day. It's the 50th anniversary of Earth Day. So I've got my LB Goes Green on. I hope everyone has a little time today to devote to green initiatives and spending time on that topic. But we've got a whole bunch of stuff on our website if you're looking for any suggestions or ideas. But we're not here to talk about green initiatives today anyway. We'll do that another day. So the topic today is really sort of a fair housing update. And one of the things that's come up a number of times with our clients in particular, in light of the CARES Act, we've had a lot of people expressing concerns about how to address issues with things like late fees and eviction cases and non-renewals. And there's a whole bunch of fair housing embedded in all of those questions. And so we wanted to take some time today to sort of go through some of the basics and sort of tie them together with the ongoing legal issues being created by the COVID-19 pandemic. For starters, the Fair Housing Act hasn't been suspended in any way, shape, or form by any of the legal events that have occurred over the last 6 weeks. The Fair Housing Act still applies. And so even though there is a crisis going on around us, the obligations under the Fair Housing Act remain. And to sort of refresh everyone's recollection, there's a list of things that you are not allowed to consider when dealing with housing issues. The idea being that the Fair Housing Act is there to make sure that you are providing equal opportunity to rent housing from you for all people who are otherwise entitled to it, and that you don't discriminate on the basis of any of those protected classifications. Now, everybody's taken a fair housing class knows that backwards and forwards. We know that protected class to investigate whether or not that's the case. And that, in the world of fair housing and the world of being a lawyer for apartment communities that deal with fair housing claims, being investigated is losing. Even if you ultimately prevail and prove that you didn't discriminate and that your policy was very much just down the middle and the resident feels like they were discriminated against, but there's no factual basis for that. The investigation itself is a time-consuming, costly endeavor. And so under the Fair Housing Act, really the mission is just as much on a real-world basis for our clients. It's just as much about avoiding the investigation altogether as it is about making sure that your policies are in line with the Housing Act itself. Because avoiding the investigation is what really is the goal here. Anytime you've created a scenario where a resident feels like they've been subjected to differential treatment or that they haven't received a fair shake, they are primed for creating the belief, at least in their own mind, that discrimination may be the cause. That may be what's behind the curtain. And if they think that they're being discriminated against, they're going to eventually speak up, and then you're going to be the one that bears the weight of that perception. Because when an investigation happens, the investigator is a employee paid by the government, whether it's a locality or whether it's HUD themselves. They have no skin in the game, they have no cost, and the resident doesn't have to incur any expense to ask for the investigation to happen. And so you are in the worst position possible because you have to defend your actions. You usually have to hire an attorney to help you, and you're the one being almost presumed guilty until proven innocent in the situation. In an investigation setting, that's often how it feels to our clients. And all of those things are bad. You have plenty to do without having to deal with a fair housing investigation. So if you're looking to avoid that, then in a time of crisis like this, you want to make sure that the policies that you do have are well documented, not hidden behind the curtain. Don't keep them secret. Don't wait for people to ask for things. Tell people what your policy is. Ask people to engage with you so that nobody can accuse you of giving them a lesser opportunity, even if the opportunity was actually equal. If it's perceived to be unequal, then that's just as bad because the perception of inequality is to most people the exact thing that leads them to feel like they've been discriminated against. So perception is reality in many ways in a fair housing claim. So in a COVID situation like this, if you're going to have late fee waivers, for instance, for people that are affected by COVID, well, that's something you need to tell people about. The key is communication. If you are communicating with your residents and giving them information, that is one surefire way to empower them and you to feel like they're engaged in the process. And when people are engaged, they feel like they have ownership. And when they feel like they have ownership, it's very hard to feel like they're being discriminated against. And that's all part of the process here. And so in dealing with COVID situations, in dealing with legal issues in a time of crisis, the need for good communication with your residents is paramount. It's always important. It's always something we talk about. But in a time like now, communication is ratcheted up by a factor of 10 on the scale of importance, because telling people what they need to know is so much more important when people are feeling scared, when people are feeling afraid, when people are feeling uncertain, and when people don't know what's coming next. They want more certainty. They want more understanding. They want more information. And the only way to get that to them is not by adopting policies like, if you ask for it, then we'll tell you. Here's another sort of real world reason why you should be skeptical of policies like that. In a fair housing context, if you have your staff on site that know that there is a policy, let's just say that if people have been affected by COVID, we're going to offer to waive their late fees for the next 2 months. But you don't tell people that. Well, your staff consists of multiple people. And if you are being honest, you, like I, know that your staff as a group have friends in the community. It's inevitable. Everybody at every community knows some of your staffers, whether they're maintenance technicians, whether they're assistant managers, whether they're brand new leasing associates, whether they live on site. They have friends in the community. And if you think for a second that your staff, who know that there is a secret policy about waiving late fees, aren't going to tell their friends about it so that their friends can take advantage of it and tell them on the down low and keep it hush hush, they will. And you're kidding yourself if you think that they won't. Now, when that happens, then you have a select group of people, friends of the community, friends of the management staff, who know about this opportunity and have taken advantage of it. But other people who were never told about it, because it was a policy that was supposed to be, if you ask, then we will tell you policy. But you know your staff have gone out and told some people in the community about the existence of the policy because they're people. It's human nature to try and help your friends. And once that happens, now you have a very big problem, because now there's a group of people that know about the policy, some of whom might actually admit that they were told about the policy by the assistant leasing person who's there on Saturdays. And once that information gets out, you can't put the genie back in the bottle. The other residents who didn't get told that information will immediately believe that they were treated differently, because truthfully they were. They weren't told. Some residents were told, a very small group of residents were told, the friends of the staff residents were told about the policy, and the other residents of the community were not. And that is absolutely positively differential treatment. And so if an investigation happened and that information came to light, it would make it very easy for the investigator to believe that discrimination might have been involved. Whether the policy was completely unintentionally neutral or not. If the policy was intended to be neutral, was intended to be one size fits all, but yet it wasn't enforced that way, it wasn't dealt with that way, and it was in fact parsed out to some people but not others, that makes a really easy investigative finding of there's cause to believe that discrimination might have been involved here. And that means that further investigation will happen. So those are all reasons under the Fair Housing Act. In a time of crisis, it's super important that everybody get the same information. So if you're going to offer a benefit only to a limited group of people, that's okay. if you've been affected by COVID, then we have the following benefits available to you. Totally fine from a fair housing perspective to say that, but you have to say it, and then you have to do it. Tell everybody, communicate, and then have policies in place for deciding what are we going to offer? What is the basis for taking advantage of the offer? What are we going to require residents to show us in order to be able to be eligible for that benefit? Those kinds of policies are the ones you want to focus on. Making sure you have good documentation, making sure you know what it is you want the resident to bring to the office in order to establish that they are eligible for your program. Things like, did the resident lose their job or have their working hours reduced? Things like, can they bring you a document that shows that? Being able to deal with that. Asking the resident to establish what impact their income has been affected by. Does it change their eligibility under your normal application standards? Do they fall below the usual 1/3 debt to income ratio, for example? All of those things are part of what the analysis should consist of. But for fair housing purposes, consistency is the key. You have to have a good set of information available. You have to make sure that all of your team members know what the policy is. You have to make sure that all of your team members are interacting with the residents the same way, asking for the same verifications, asking for the same kinds of documentation, using the same people to make the ultimate decisions. If you need to decide, is this documentation sufficient, you want to make sure that you have someone who's in charge of making that decision so that the decisions get made the same way all the time. There's consistency in the decision-making process. You can't have different answers being given to different residents that have similar looking information. You want to make sure that you have a very uniform set of communication styles. I have one client that we did a lunch and learn for yesterday who directed all of their communities to funnel all questions of eligibility to one regional manager, and only the regional manager can give answers. Why? Because that way the regional manager is the only person who's responsible for the output. And you have reduced the chances of different information, different outcomes being received by the residents at the communities in your portfolio. And it's a really great way to make sure that as long as you have someone who's reliable to be in that function, keeping as few people from the decision-making loop as possible is a great approach in a time of crisis like this, where you have to make real decisions in real time without a lot of setup, without a lot of advanced opportunity to plan, and you have to be able to execute in a crisis. Having fewer people involved always is a good idea. Too many cooks in the kitchen is a real thing when it comes to things like this. For fair housing purposes, if you have multiple people making decisions about who's eligible and who isn't, every additional person creates one additional level of risk that a fair housing claim might happen at one apartment community for one resident because they didn't get the same output, the same result as a resident at that same community or even at a different community. And that is the risk that you're trying to avoid in times like this. You don't want different results. People are paying very close attention to what's being done to help them. They're paying very close attention to what benefits are they getting, what opportunities are they being told about, and being uniform about it, being consistent across all your messages and across, most importantly, across your outcomes is the thing that's of paramount importance. Because anytime there's a disparate result, residents will eventually talk to each other. And in a time of crisis like this, especially when people are home and they're on social media sharing information, it's easy for them to find out that Joe got this thing and Susie didn't. And Joe and Susie are going to want to have the same result. They're going to expect that they're going to get the same result for the same reasons. So all of that coming together is in a time of COVID crisis like this one, really leads to the only possible outcome that you really need to be aware of is that you've got to understand this is time critical. Communication is important, and uniformity of results is important. And so the less variability you can have in your systems today, the better it'll be. Residents will just make it super hard for you to get away with some things that you might otherwise have gotten away with in the past. So in a time of crisis, you really need to be mindful of ensuring those kinds of outcomes. So when you're dealing with issues like late payment plans or partial payment plans, another one that's very popular now that creates some fair housing concerns. So lots of people are implementing a number of possible opportunities for their community. It varies from management company to management company. But the NAA put out a document that most of you have probably seen by now. And the operational best practices document, Michael's popping up on your screen now, is a super important place to go for information about stuff like this. If you're looking to make sure that you are achieving the best results and you are doing what you can to stay consistent and to implement policies and procedures for your community, this is an invaluable page to keep in your toolbar. We're going to share this with you at the end of the seminar, so you'll be able to access it. But as you can see here, the operational best practices that NAA has put together goes down the list of operational issues to rent collection issues. There's forms, resident exposure, what happens if you have a resident on site, and then there's free forms for resident relief requests. All of those things are super helpful, and we encourage you to reach out to NAA if you have questions. Donald can help you access these, but the forms are open to the public. If you're anyone in the industry, you have access to these things. And the ability to offer a payment plan agreement, notice of temporary waiver of late fees, those are great ideas that are almost universally being adopted in some form or fashion during this period of time. How long they last will be a question that remains to be seen. But offering people these payment plans is everyone's best opportunity. It's almost a best practice in this time, where you have a payment plan agreement where residents are, even if they've been unemployed, what we know is that residents are getting benefits from their states for unemployment benefits, and the federal government has even agreed to pitch in an additional $600 on top of that as a stimulus-related opportunity. So what we know is that even if you're unemployed as a result of this virus, you're not going to suffer an economic hardship for very long. But what maybe most of the residents do need is help with April. While we wait for the paychecks to start rolling in, people to get reemployed, or while we wait for the unemployment benefits to show up, people need some help. And if you are doing a good job of keeping your fair housing training in mind, you'll be using things like this uniformly, and you'll be developing policies that really help you put this in place across a solid spectrum of your community without segregating between people in a way that will lead them to feel like they might be receiving disparate treatment. And that really is where the NAA guidance can come into play for you. It can really be a huge help if you're looking to make sure that you've got all of the issues encountered and taking into account. And without some guidance from places like the NAA, I think a lot of our clients were struggling. But I think now everyone's pretty clearly gotten this idea in mind. And I think if you're using these resources, it's going to be a huge help to keeping you on track and keeping you from getting too far afield, exposing yourself to a fair housing opportunity for a resident to claim one anyway. The other thing that we wanted to talk about today is a couple of other issues that aren't COVID related. And I'm going to move on. If we have COVID related questions, we'll certainly cover those. And again, Michael is keeping track of them, so feel free to message him if you've got some specific questions about COVID related responses and how to use best practices to keep things from getting out into a place where they can be creating issues. But in other fair housing news that isn't COVID related, every April, the U.S. Department of Housing and Urban Development, HUD, observes Fair Housing Month. So sadly, Fair Housing Month is getting a little bit of short shrift this year because of the presence of the pandemic. But the theme for this year's Fair Housing Month is call HUD because sexual harassment in housing is illegal. if you were in the session before I was able to join in, we had the infographic that HUD created for this up, and it'll be part of the email that goes out later, I'm sure. But one of the things that is super critical and that HUD wanted to communicate during this Fair Housing Month is that the existence of sexual harassment in housing is a real thing. And sadly, it's one of those types of discriminations that often goes underreported. And that's why HUD, I think, has chosen to make it, to bring it into the spotlight this year and focus on it a good bit. So we'll spend the rest of our session today talking a little bit about that. There's plenty of resources for it. The assistant director for Fair Housing and Equal Opportunity wrote a letter actually as part of the Fair Housing Month celebration. And she wanted to make sure that she highlighted for everyone that while there's no quick end to the pandemic in sight, how the pandemic affects housing choices in the weeks to months to come is not yet known. But it is also going to create an opportunity or a potential for fair housing and civil rights claims to exist based on whether it's race, national origin, disability, any of the other listed categories to be violated. In fact, HUD has heard, as you might be surprised or might not be surprised to learn, they've already started receiving complaints about people being denied housing because of coronavirus fears. If you were one of those folks that is still conducting business and you're offering tours to the public, considering whether or not someone might have been exposed to the virus is not a permissible way to evaluate their application. And I am not surprised at all that HUD has already started hearing those complaints because you knew that some residents are gonna, or some applicants at least, were going to have that come up. What if you're a first responder? What if you're a nurse that works in an ER? How is the on-site staff going to treat that? If the on-site staff is being stressed to the max by having to deal with possible infections and having to deal with all those issues, it is entirely reasonable to imagine that some on-site community staff would say, we're not going to approve that application because we cannot afford to have someone with the virus in our community. And an emergency responder type is exactly the person who would be in high risk for getting it. Well, that's a giant disaster waiting to happen. It might be true that you don't want to have people exposed to the virus in your community because that creates a nightmare of operational issues. But that doesn't mean that you're allowed to exclude them. If they did have the disease, that would be a disability into and of itself. And it's plainly illegal to discriminate against someone because they have a disability. Having a health condition like the virus doesn't absolve you of the obligation to comply with the Fair Housing Act. The Fair Housing Act has not been suspended by the pandemic. And so things like that are super critical. HUD is going to be watching for that. If you hear of people that are doing that, you should dissuade them as strongly as possible. You cannot.
Chris?
Yeah.
Yeah, it's an undisclosed phone number, and so we didn't know it was you, but now you are unmuted via phone.
Okay. All right.
Sorry.
I have no idea what's wrong with the meeting, folks. It refuses to let me reconnect. So, sorry. I apologize. I've done everything I know to do on my end to reconnect. Okay. Well, so back to fair housing issues. So the Housing and Urban Development Department has issued funds to its fair housing partners, and that means that investigations are going to actively be happening as we go forward through this crisis. And so I think it really is important to remember that this is not a drill. They are going to be looking for evidence of instances where folks with COVID-related issues were treated differently. And so I think it's super critical to be mindful of how you handle new applications and any other issues. Things like reasonable accommodation requests. Think about if you have elderly residents who may have a disability or even just a regular resident who's disabled. Think about how you have to modify that. You may have policies on your site right now where you're not doing regular maintenance requests or repair requests, only emergency ones. Well, what if you have a resident who has a specific need for a repair? An example I gave recently was, if you're performing repairs on things like refrigerators because they are more critical items, but you're not performing other miscellaneous repairs. What if a resident were to call you and say, my ceiling fan stopped working in my bedroom and I need the ceiling fan replaced or repaired? You cannot just simply approach that from a standpoint of one size fits all answer. If you say, no, we're not repairing ceiling fans right now, what if the resident has a breathing disability or has sleep apnea and needs the air circulation to be functioning in their room for health reasons? Well, they have a disability. They may need to be accommodated differently, even in a time of crisis where that may need to be an exception to your regular rule of we're not doing non-emergency repairs right now. That's the kind of reasonable accommodation request that you need to be mindful of. What about if someone is an elderly resident who doesn't have access to an online payment portal and they need to make their rent payment, but your office is closed and you're not accepting walk-in visits from people to pay their rent? You may need to accommodate that resident who has a disability by installing a drop box, even though you don't usually have one. If the resident raises that as a concern and says, I need assistance being able to pay my rent, and you may have to strongly consider implementing that policy as an accommodation request, because a Dropbox doesn't cost anything, at least not anything substantive. And it may be that that resident who has a disability and has a hard time using the internet may not be able to make their payment electronically. And so you have to be mindful of that. Reasonable accommodation requests in a time of crisis are especially complicated because you are worried about your own staff's health and well-being. But that doesn't take priority over the Fair Housing Act, and the obligation to provide reasonable accommodations is always in place, isn't going away, and hasn't been suspended. So being able to consider things like that is a key part of responding in the time of crisis. Remembering your fair housing training in every interaction with your residents is a super important piece of the puzzle. You cannot just have residents receiving poor levels of fair housing related treatment in this time without running the risk of being reported when people get the opportunity to raise those issues. They're gonna. So keep those things in mind. Everything is not one size fits all. Even though your community policies may have changed, you do have to be mindful of the need to still be considering things like reasonable accommodation requests from residents who have a disability related need. And that's going to be a challenge. Again, back to my earlier point about communication, having somebody be a point person like a regional manager who's got the responsibility level for helping deal with those issues. Really important in these times of crisis that you lean on those resources when they're available to you. And if they haven't been obviously communicated to you, reach out and be proactive and ask for help. How do I respond to this? I'm worried about a fair housing issue. Do I need to make a reasonable accommodation here? Let the people know that can help you make good decisions so that you don't find out later that your decision in the moment was not as good as it could have been and it resulted in a fair housing claim that you end up in the front of. You're going to be the one that gets investigated. You're going to be the one that has to answer questions about why did you do what you did? Why didn't you do something different? You're going to be the one dealing with that. HUD in this particular year, back to our Fair Housing, April's Fair Housing Month, HUD is particularly focused on continuing its commitment to protecting the rights of individuals to enjoy their homes without having to endure degrading or other sexual harassment or unwanted sexual advances, which is why the theme for this year's Fair Housing Month is because sexual harassment in housing is illegal. It's especially appropriate. It reflects HUD's continuing efforts to combat this form of discrimination. They want to bring light to it. They want to make sure that more people are aware of it. I've been teaching about it for a while now, but in 2016, HUD enacted a rule that really makes sexual harassment in housing discrimination come to life. And I think in the years that have intervened, the 3+ years since then, it's only now starting to really gain attention. And I think that's one of the reasons why HUD made the decision to use this year's Fair Housing Month as an opportunity to highlight the sexual harassment issue, because it really hasn't gained a lot of traction on its own. It hasn't really been widely publicized, and it hasn't really been one that people have started to pay enough attention to yet. So this year they're doing that, and they want people to be aware of it. One of the things that they did in their announcement about this year's Fair Housing Act Month and using sexual harassment is they publicize some recent enforcement actions to get people some real world examples. For instance, earlier this year, HUD entered into a conciliation agreement with a property management company out on the West Coast that had a property manager who was apparently engaging in sexually harassing behaviors with the residents, was trading favors with residents, was expecting sexual favors in result for certain activities, and got reported. And HUD made public the fact that they had settled that discrimination claim with the property management company, and also named the property manager themselves as part of the enforcement action. And it got settled for $63,000, and that was per claim. And so when you're talking about numbers like that, it starts to get people's attention, and HUD has decided that one of its vehicles for trying to gain more notoriety out of the Fair Housing Act issues that it's pushing is to highlight the actual dollars that are being spent by people who are caught with their hand in the cookie jar. And so if you're thinking that sexual harassment in fair housing related terms is something that has happened, but what kind of, how big of a deal is it? Now you have some real tangible economic numbers to work off of, and that's why I think HUD putting that out there. If you added, if you had one property manager that caused two residents to file claims and they got joined together, and you ended up having to pay $125,000 to settle those two claims, I think your company would sit up and pay attention. And I'm pretty sure you wouldn't be employed with that company for very long either. So that's why sexual harassment in housing is such a big deal, and really is important for everybody in the industry to be mindful of, because sexual harassment in housing can happen at any level of your staff. It doesn't have to be the property manager who is the one doing it for it to be a problem. Anybody who is in your employ and who is on site interacting with residents or applicants could potentially be creating liability for you if they are engaging in practices that indicate that sexual harassment is going on. So let's take a quick refresher. Sexual harassment in housing. There is an information sheet that HUD put out that I think Michael has access to, and I hope he's sharing on his screen with you now.
Yep.
But it's, what's that?
Yep, it's the one that says, what is sexual harassment at the top?
Well, there's another one that's called sexual harassment in housing.
Yep.
Yep. And so this one, I encourage all of you, we're going to go through it real quick, and then we can answer questions about what's on this sheet. But this is the best reference guide that I've seen, and it's, of course, come out recently. And so I encourage everybody to keep this handy and use it for your on-site teams. The Fair Housing Act and other federal laws prohibit sexual harassment. These laws also prohibit harassment because of race, color, religion, national origin, familial status, or disability. Again, there's your list. For those of you that like to have the list handy, you're not allowed to treat any of those people differently: race, color, religion, national origin, familial status, or disability. All right, so the first question, of course, that everyone asks is, what is sexual harassment? When you say sexual harassment in housing is illegal, that's nice, but it doesn't tell me what we're talking about. What's the definition here? So we start off. Sexual harassment in housing is a form of sex discrimination prohibited by the Fair Housing Act. It's also prohibited by other federal laws, like Section 109 of the Housing and Community Development Act of 1974 and Title IX of the Education Amendments of 1972. There's two main types of sexual harassment that HUD has defined. One is quid pro quo sexual harassment, and the other is hostile environment sexual harassment. We'll talk about each one separately. So quid pro quo, we start with that one. That's super fancy Latin, and it's a legal term that means this for that. It is literally the Latin equivalent of, if you scratch my back, I'll scratch yours. Quid pro quo harassment occurs when a housing provider requires a person to submit to an unwelcome request to engage in sexual conduct as a condition of obtaining or maintaining housing or housing-related services. For example, what does that mean? They get some great examples. A landlord tells an applicant he won't rent her an apartment unless she has sex with him. That's obviously wrong. That's an easy one. A property manager evicts a tenant after she refuses to perform sexual acts. Also ought to be easy to spot as clearly wrong. What about this one? A maintenance man refuses to make repairs unless a tenant gives him nude photos of herself. Now we're getting into a category that's a lot less open and obvious. You have people that go into residence apartments on a regular basis. Any one of those visits to an apartment is an opportunity for bad things to happen. That's always been true, but it's also true in this regard. If a resident is, I have a good example that I use when I teach this class in a more thorough way, and I'll use it here. It doesn't just have to be the gross, nasty kind of sexual harassment to be quid pro quo liability. If a resident believes that sexual favors are what's being talked about, that also qualifies. So even if what's going on is a less prurient, less sexually obvious issue, it can still get us to this point. Think of the instance where you have a community being renovated and you're taking it one building at a time. And in the building being renovated, the units are being turned into upgraded model type units. They get new stainless steel appliances, for instance. Well, let's say one of your maintenance team members is in a relationship with one of the other residents, and that resident gets a fancy new upgraded stove and refrigerator as a result of their relationship with your maintenance member. Well, it would be pretty easy for a different resident to claim that I asked if I could get an upgraded stove and they said, no, it wasn't my building's turn, but I know that Jane, who lives in my building, has those, and it's because she was doing sexual things with the maintenance team, and that's why she got them. That would also be a sexual discrimination claim under the Fair Housing Act. It would be a claim not that you were required to do it, but that because Jane was in a relationship with the maintenance guy, she got the benefit and I didn't. That would be an easy way to claim quid pro quo sexual harassment. Because I didn't do sexual acts with the maintenance guy, I didn't get the upgraded appliances in my apartment like Jane did, is the reverse of quid pro quo. It's not that I didn't give the maintenance guy sexual favors or that I refused his advances. It's that clearly if I were doing it, I could get those just like Jane did. It works in all of those contexts. So anytime you have that sort of relationship going on, you have the possibility of a claim for quid pro quo liability. It's obviously wrong to openly engage in trading sexual favors for anything on site. But as a management team, how often do we really actually keep an eye out for this thing? How much investigating do you do? How much information do you gather about those kinds of issues? I think the real question to ask yourselves is, how can you upgrade your maintenance? How can you upgrade your operational style to account for the possibility that maintenance team members might be doing things like this behind closed doors when they're in an apartment with somebody? How do you figure out when to take that sort of thing into account? How do you make sure that you're being mindful of when residents are reporting that? Do you give them an opportunity to report things like that? And if so, how? Is that opportunity well publicized? Do you have any information sheets that tell your residents, if you ever experience an unwelcome advance from our team members, please let us know? If you have that, I don't see it very often. I see a lot of documents from clients, but I haven't seen any that highlight that issue as one that people are being readily made aware of. Again, communication is important. Telling people that if they feel sexually harassed by a member of your team, they should have an opportunity to report that safely, securely, privately. That's not something I see very often from my clients. It needs to become part of your lexicon. It needs to be part of what you do on a day-to-day basis. And how you do that is very much a part of evaluating these situations and evaluating what can work on your community. But the ostrich approach of sticking your head in the sand and pretending like nothing is happening unless somebody comes in, bashes you over the head with it, is not a good idea. That's how you end up in the case of a fair housing claim for $125,000. Because you let it go on, you let it go unchecked, you don't have methods and operational procedures that allow for those sorts of things to get reported easily until they reach a boiling point, and then you find yourself past the point of no return, and you end up settling fair housing claims for lots and lots of money instead of nipping them in the bud much sooner in the process. and weeding out a bad manager who was engaging in inappropriate contact with residents long before it got to this point. The second type of sexual harassment is the last type we'll talk about before we finish our talk today, hostile environment harassment. And this one is, I think, even more fun to talk about, at least for me, because it has so many permutations. Hostile environment harassment in the housing environment occurs when a housing provider subjects a person to severe or pervasive, unwelcome sexual conduct that interferes with the sale, rental, availability, or terms, conditions, or privileges of housing or housing-related services, including financing. All right, so let's start with that before we get to the examples. This type of harassment, hostile environment harassment, is very much the housing equivalent of a more well-known cousin to this, which is hostile workplace environments. That's part of our collective knowledge. We've all learned about what hostile workplace environment sounds like. That is what this was modeled after. When HUD enacted this rule in 2016, they were specifically modeling that particular long-held statute that people are now very familiar with. Unwelcome advances in the workplace are against the law. Unwelcome advances in housing situations are now also clearly and unequivocally illegal under the Fair Housing Act based on the 2016 guidance from HUD. So how do you know if you've been the subject of hostile environment harassment? If you are a person, like a resident, who has been subjected to severe or pervasive unwelcome sexual conduct. Severe or pervasive is a challenging term to define clearly. It does have to be repeated. It does have to be significant. It cannot be something of your own imagination. But unwelcome sexual conduct is a very complicated standard. Unwelcome means it's very much about the eye of the beholder. The person who is reporting it to you does have a say. If it's unwelcome to them, they're allowed to report it. And does it interfere with their use of the privileges of the housing or housing-related services? So having to take all of those things into account, what you're going to see is that in today's era, under this, using this standard, a lot of things that used to be treated by my clients as, well, that's just a resident versus resident problem. I don't have to worry about that. That's no longer true. Under this version of the law, under this understanding of how the Fair Housing Act works, if one resident comes to you and complains about another resident who they believe is subjecting them to unwelcome sexual advances, you have to do something about it, even though it doesn't involve your staff. This doesn't relate to just what your team members do. It relates to the entire experience of the resident. And so if they are experiencing unwelcome sexual conduct on the property by anybody, including an off-site vendor, for instance, they have the right to bring that to your attention, and you have an obligation to ensure that they don't suffer hostile environment harassment. You have to do something about it. That is a brand new and very much not well-known issue. For example, if a landlord subjects a tenant to severe or pervasive unwelcome touching, kissing, or groping, or even not physical, a property manager makes severe or pervasive unwelcome lewd comments about a tenant's body, or a maintenance man sends a tenant severe or pervasive unwelcome sexually suggestive texts and enters an apartment without invitation or permission. Social media is a very big place where this is being enforced. Lots of the enforcement action that does go on right now using this form of Fair Housing Act violation relates to social media conduct. Lots of people sending direct messages to residents and making residents feel unwelcome, have a hostile environment approach. But here's the example I give when I teach this is even more direct and even more to the point. What if you have a resident, of course, everybody has a pool, so someday we're going to have our pools open again. And what if you have a resident who is a young female resident who likes to use the pool to sit out after she gets home from work as a teacher every afternoon at 4 o'clock? And she's out at the pool, 3 out of 4 days a week, that she's, sunny and useful. There's another resident who lives in one of the apartments near the pool, and he is also a teacher and comes home from work every day about the same time. And he, however, doesn't like the sun and likes to sit in the shade. So he sits on his porch every day with the Wall Street Journal and spends about an hour reviewing the paper while he sits on his porch enjoying the outdoors. He has a direct line of sight to the pool. The resident who's at the pool, she can see him and he can see her anytime they want to. If that female resident comes to you after 2 or 3 weeks and says, I feel like the gentleman who lives in that apartment right across from the pool, I feel like he's giving me unwelcome sexual advances. I feel like he's ogling me every day. I'm out there in my bathing suit and I'm just trying to enjoy the pool. And every day he's out there on his porch and he's staring right at me. Well, this is a very complicated problem. This is not a problem that you can just ignore. Using this standard of hostile environment harassment being unwelcome sexual conduct that interferes with the availability of terms, conditions, or privileges of the housing. Well, use of the pool is one of those privileges. Having unwelcome sexual advances interfere with your ability to use the pool would fit the definition. And if it happens regularly or pervasively, like 3 or 4 days a week, you're experiencing what you think is being ogled by another resident while you're in your swimsuit at the pool, that meets all the criteria of that definition. And so the resident who comes to the office to report that is making a claim that they feel like they have hostile environment harassment going on, even if they don't know that's what they're saying, and even if they don't know hostile environment harassment is a Fair Housing Act violation. You, the professionals, need to know that that's what she's saying, and you need to treat it like a Fair Housing Act claim. And let me tell you, that's an eye-opener every time I say it, because it's an experience that almost everybody who's been in this industry has had. And in years past, it was a no-brainer. I'm sorry, you guys just got to get along. I'm sure it's fine. No big deal. Please don't let them bother you. Today, under this standard, you have to treat that as a Fair Housing Act problem, and you have to investigate. You have to interview people. You have to find out, what is that guy doing? Is he ogling her or not? You have to actually take steps to figure out, what can we do to solve this problem? You cannot pretend like it is one resident versus another resident and have it be their problem. It is now your problem. And in exactly that same kind of way, in today's era of Fair Housing Act enforcement, you as the professionals on site are expected by HUD to understand that your job is not to simply blow off information like this. Your job is to take it seriously and to investigate and to find out what's going on and to reach conclusions about it. If you find out that one resident is ogling another resident at the pool, then you need to actually use your power under the lease to terminate that man's lease and tell him he needs to leave because he's engaging in unwelcome conduct that violates the provisions of his lease. That is a whole new ball of wax, boys and girls. That is not something that anybody on this call has ever filed a lawsuit about. We've never filed an eviction action for that, but that's exactly what HUD is expecting. If you find that unwelcome sexual conduct is happening and that a resident is experiencing a hostile environment because of the actions of another resident, HUD expects you to do something about it because your lease gives you the power to do that. You can terminate the one resident, you can tell them to leave, and you can make them leave through the power of the court system. If you don't think that that is a big deal, just wait and see, because somebody is going to be the victim of a HUD enforcement action, and they're going to be publicized about their failure to take action on behalf of a resident who was experiencing hostile environment harassment. It may take till next year, it may take till 5 years from now, but I assure you it's coming. There's no two ways about it. That's what this whole document is designed to tell you, is that HUD is ratcheting up its monitoring of this situation. It made April's Fair Housing Month this topic. Sexual harassment in housing is now a real thing, and HUD wants everybody to know it. That's why they put the spotlight on it this month. And so if you have a sexual harassment situation going on your property, you need to be mindful of it and really reach out to your counsel when you have this problem come up, because it's new, because the people in the industry aren't familiar with it. Anytime we have this, the most important thing you can do is ask for help from people who know what they're doing. If you try and do it yourself using common sense, you're going to find yourself on the wrong side. And HUD doesn't care that it's common sense that you used. HUD doesn't care that you didn't mean to discriminate. HUD doesn't care that the standard is complicated and new and unfamiliar to most everybody in the industry. HUD expects you to learn and to apply that knowledge when you leave here today, you now know more than probably 75% of your industry professionals do about what to be mindful of and how to be careful. Do something with that knowledge that's protective of your community and of yourself. Because if there's a fair housing investigation, your name will be on it. If you were the property manager that didn't take action, I assure you that the young female resident at the pool will ask HUD to investigate not just your apartment community, but you specifically, because they talked to you and you didn't do anything. Your name will be on the investigation, and that is reason itself, all by itself, for you to make sure that you take the steps necessary to do things better before you end up the source of a fair housing complaint and the respondent to an action like this. Okay, that's all the actual talking. How about questions?
We do have one question that came in through the chat, and it is from Samantha Hoover. Samantha was wondering, do you have any thoughts or ideas on how to handle a move-in for a partially occupied unit, i.e. student housing, during all this COVID stuff?
I think you have to approach it from the standpoint of you have to be able to do it. And so, people have to be able to move in, and whatever the policies you need to implement are, you need to make sure they're clearly communicated to people. But you've got to develop some sort of protocol with people to say, we have a new move in, we need to make sure that we're following all the social distancing guidelines. So in order to do that, we need to do A, B, and C. I think that absolutely you want to have a protocol for that. You want to communicate it to everyone so that it is easy to fall back on, this is what we're doing and this is why we're doing it. Whether that's arranging for a time for the move-in to happen when the other residents will not be in the apartment, those are the kinds of things that come immediately to mind. Ensuring that new move-ins are supervised might be another way to deal with it. You have a member of your staff there to supervise and provide help, so that you can make sure you're complying with all of the guidelines. There's no one right answer, but it is definitely something that is worth being mindful of. Yes.
Okay. Well, I think that's everything. There were no other questions in there. Samantha said thank you, so I think you covered it for her.
Awesome.
Donald is going to send out a follow-up email later today, probably, or tomorrow. He's going to send out all the links that I provided in the chat as well. If you want those now, before you leave the Zoom meeting, there is a way you can click the 3 dots and tell it you want to save the chat, and that'll download all of that directly to your computer. We'll also be editing and sharing a link with the video later on. We'll get rid of all that dead space in the middle when we lost Chris. And if you have any other questions or if you need anything, please don't hesitate. Reach out to Donald there at the association, or feel free to reach out to our firm. We're here for you and happy to help. So everybody have a great day. Thank you again, Chris, for your time. We appreciate it.
Thanks, everybody.